Good morning, everyone. This is Kristen O'Neill with the New York State Committee on Open Government. We'll get started. Actually, it's 10 o'clock, so we can get started now. I'm going to just scooch some things around so that they don't block the screen. To get started, I'm going to include in our chat feature. I'm going to shrink this out so I can put a copy of our website in the chat feature. So right now, if you go into the chat feature, you're going to see a link to the Committee on Open Government's website. The next thing I'm going to do is include a link to where training materials can be found. So on that second link, it will bring you directly to where I post the recordings of these programs, of my information sessions that I've been doing. It brings you to a link to our YouTube page. I always recommend people, if you're going to choose one of the videos to watch, it's probably best to choose the ones that are that are the most recent. Someone just asked if we are all muted, and yes, you are all muted. I think that probably the best way, oftentimes we get, I don't know that we have a particularly large crowd on the webcast today, but sometimes we have a large crowd. So I've found that the best way to handle that is to mute all my attendees and have conversations through the chat feature. So I apologize. Sometimes if I'm pausing and sound a little bit puzzled, it's probably only because I'm just trying to, to keep up with anyone that's asking questions in the chat feature. I do want to let everyone know that I'm not really any way for me to provide tech support. So if you're having a difficult time, if someone, can't hear me or is having difficulties in any way, there's probably not a whole lot I can do at this point. But if you have questions afterwards, after the program about the presentation, feel free to contact me directly. So right now, I'm going to go back to my PowerPoint, just a moment. Slide view. Wonderful. Okay, so this morning we're going to be talking about the New York State Open Meetings Law. We're going to go over the basics of the statute, but also talk about the things that have changed in the past couple of years, particularly with regard to video conferencing. Things have been steady for a little while now, probably for about a year. Things have been fairly steady in terms of no major changes with regard to the open meetings law, but the past couple of years have been quite a bit to keep up with. So I cannot blame you if you're sort of lost as to where we are in terms of what is and what is not permitted. Up on the screen right now, you'll see that's my contact information. Our telephone number for our office. For those of you are not familiar with the staff of the Committee on Open Government, we're a very small office. We have our executive director and then myself. I'm the assistant director, and I'm also director of training for the Committee on Open Government. So if any of you belong to an organization or a municipality that would like to request training, there is a link on our website for contacting me to request training for your organization. The information doesn't really change from these, or not particularly different from the information sessions that I provide virtually, but if I come and do a program for your municipality, it does give you an opportunity to have a little bit more of a Q&A and to focus on the issues that are of significant interest to your group. Our website is opengovernment.ny.gov, and the email address, if you have questions regarding the Freedom of Information Law or the Open Meetings Law, the best way to go about submitting that question is through our office account, which is our acronym COOG, Committee on Open Government, at dos.ny.gov. Not that if you have my email address, you're always welcome to contact me via email. But sometimes I'm traveling on the road, and I may be delayed in getting back to you. Whereas if you send an email to our Goog account, you're more likely to get a quick response. In addition to our executive director and myself, we do have one senior attorney who is currently on family leave, which is wonderful for her, but we miss her terribly. And we just started, we have a new Excelsior fellow that just started at the end of August. So he's sort of he's learning, he's doing wonderful, he's picking up everything very quickly, but he is new to our office. So that is where we are right now in terms of staffing, and I just want to make sure everybody's aware of that. Up on the screen, you see a picture of what our website looks like. Our website on that home page, right where it says Committee on Open Government right now, we call that our large banner. Anytime anything new and exciting is happening, we try to put that right up on our new banner, on our large or one of the small banners there up on our website. Any important information relating to changes to the open government statutes, we're going to try to get that information up for you onto our website. When we have meetings of the Committee on Open Government, we put that up on our website, or if I'm doing trainings. So it's a good place to check in periodically to see if there's anything new and exciting going on in the world of open government. The Open Meetings Law is codified in Public Officers Law Article 7. And we maintain an up-to-date copy of both the Open Meetings Law and the Freedom of Information Law on our website. So if you go back to our website, you may notice that there's a series of headings at the top of the page, and each of those headings has a drop-down menu which will bring you to, for example, the Freedom of Information Law, the regulations, our advisory opinions, our case law summaries, and the same is true for the Open Meetings Law. We have a contact us page and information about events and trainings on that homepage as well. But in terms of trying to find a copy of the Open Meetings Law or the Freedom of Information Law, the best thing to do is the easiest thing to do, I should say, is to go right to our website. All right. So the Open Meetings Law was passed in 1976, and the legislative intent stated that it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. The law also states that citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. So the Open Meetings Law doesn't just pertain to situations in which public bodies are making decisions where they're voting. It applies to any time a public body is meeting collectively to discuss public business. The term public body is defined in statute. And up until a couple years ago, it was fairly straightforward. It's become slightly more complicated through a legislative amendment in the past couple of years, but I'll try to break it down for you. So the existing language that has been in effect since essentially the beginning of the statute is that a public body is any entity for which a quorum is required in order to conduct public business, which consists of 2 or more members performing a governmental function for the state or for an agency or department of the state, or if a public corporation is defined in Section 66 of the General Construction Law. And what is a public corporation? Public corporations are counties and cities and towns and villages, school districts. So any governing body of any of those public corporations is going to be a public body subject to the Open Meetings Law. In addition, the statute has always included within that definition of public body any committee or subcommittee consisting of members of the public body. So I want everyone to mentally put a period there because this is where it gets a little bit confusing. So let's say, for example, you have a 9-member city council and you have designated 3 of your city council persons to serve on a committee. That committee, by statute, by law, has now become its own public body. So the city council by itself is a public body, and now the committee that is made up entirely or primarily of members of the city council is also a public body that must meet in compliance with the Open Meetings Law. Other entities that are also considered by statute to be public bodies are entities created or appointed to perform a necessary function in the decision-making process, and also for which a quorum is required and consists of 2 or more members. Here, what I think of when I see this language are the types of entities that are created by statute to perform an essential function. For example, the Committee on Open Government is an 11-member body created by statute to serve a necessary function in the decision-making process of both the governor and the legislature, because we have a statutory obligation to, for example, provide oversight over the open government statutes and to prepare an annual report to the governor and the legislature every year. We are required by statute to do that, making recommendations to report on the activities of the committee, but also to make recommendations for any changes we believe would be appropriate for the open government statutes. So that's an example of an entity created or appointed to perform a necessary function in the decision-making process. Other examples are things like, for example, at the town and the village level, there are entities that are created pursuant to town and village law called comprehensive planning committees. And there's specific provisions of those, of both New York State town law and New York State village law, that create these special boards for the sole purpose of either creating or amending a town or a village's comprehensive plan. So that's another example of an entity that is created or appointed to perform a necessary function in the decision-making process. The law, this definition of public body goes on to clarify that a necessary function in the decision-making process shall not include the provision of recommendations or guidance which is purely advisory and does not require further action by the state or agency or department or public corporation. So sometimes you have entities that are created, oftentimes at the municipal level, that are purely voluntary. Perhaps either the mayor or the superintendent of the municipality has decided that they want to try to get input from the public on a particular topic. So they create something called maybe a Parks and Recreation Advisory Committee, or a traffic study task force. And the purpose of these is to get input from members of the public who have a vested interest in these issues, but these entities do not have any final decision-making authority. Their sole purpose is to come up with recommendations, to sort of do the legwork and the studying, to come up with ideas to recommend to the governing body of that municipality. And again, if it's purely voluntary, if it doesn't serve a state statutory function, it probably does not require any further action by either the state or the municipality. It's just that the municipality is voluntarily reaching out to these members of the public to try to get input. So there's no obligation by the state or the municipality to accept these recommendations. It's just probably a good idea, because why create this advisory body or the task force in the first place if you're not going to at least listen to their recommendations? So here are just some bullet points about the types of questions that I ask myself when someone contacts me to find out whether a particular entity is a public body that is subject to the open meetings law. Have two or more people been given the authority to act collectively? Is a quorum necessary in order to conduct public business? Is it a committee made up solely or primarily of members of the larger public body? Does the committee serve a state statutory function? Is that state statutory function more than merely providing advice? And the alternative, is the entity purely advisory in nature with no statutory duties or final decision-making authority? So that's just sort of an overview of the questions that I ask myself when I'm trying to determine whether an entity is subject to the open meetings law. So I've used the term quorum a couple of times, and so I just want to go over what that definition, what the term quorum means. And you can find the definition of quorum in New York State General Construction Law, Section 41. And it reads, whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly or as a board or similar body, a majority of the whole number of such persons or officers gathered together in the presence of each other through the use of video conferencing shall constitute a quorum. Definition then goes on to state that not less than a majority of the whole number may perform and exercise that power, authority, or duty. And for purposes of this provision, the term whole number means the total number that the body would have if there were no vacancies and were none of the persons or officers disqualified from acting. So using our own Committee on Open Government as an example, by statute, by New York State Public Officers Law, the Committee on Open Government at full strength is supposed to have 11 members. And the statute dictates what type of people are supposed to serve on the Committee on Open Government. It says, okay, well, the Secretary of State, for example, always serves, or his or her designee always serves on the Committee on Open Government. There are a couple of positions such as the Director of Budget, the Office of General Service, and the Office of the Lieutenant Governor. Those are the positions where either that individual who's in that position or his or her designee is the person who serves on the committee. In addition, the governor gets to appoint people to the committee, as does the Senate and the Assembly. So at full strength, we're supposed to have 11 people, which means that a quorum of the Committee on Open Government is always going to be 6 people. Even though right now at this moment, we only have 9 people. We're down a couple of appointments. We're waiting to get those last 2 appointments filled, but right now we only have 9 people serving on the committee. Doesn't matter. Quorum of the Committee on Open Government is always going to be 6, because the whole number that we use to determine quorum is 11, because that's what the statute states we're supposed to have on the committee. I'm going to take a quick administrative break right here. I always like to wait a little while before I state this, because sometimes people are late logging on. But I do want to mention that, one, that this program is being recorded, and hopefully by either the end of this week or maybe the middle of next week, depending on how busy our IT staff is, I will get a recording of this program posted to our YouTube page, which is linkable from the Committee on Open Government's homepage. If you go to our homepage, you scroll down a bit, you're going to see a section that says, I would like to view training materials and recording. So for there, you'll be able to link to our YouTube page and find a copy of this recording. In addition, from that link, you'll be able to find copies, PDF copies of both this PowerPoint and a PDF copy of the PowerPoint that I use for my Freedom of Information Law information sessions. So that's my bit of housekeeping business that I always like to wait a little while for the people that logged on late. So now we're going to spend a little bit of time at the beginning of the program to talk about the relatively new video conferencing provisions that have gone into place through an amendment to the Open Meetings Law in the spring of 2022. So in April of 2022, Governor Hochul signed Chapter 56 of the laws of 2022. Chapter 56 was actually the entire New York State budget for the 2022-23 state fiscal year. So if you look for Chapter 56, it's going to take you some time to track down the specific language relating to the Open Meetings Law. But I can always point you in that direction if you're so inclined. So included in Chapter 56 was an amendment to the Open Meetings Law to expand the use of video conferencing by public bodies to conduct open meetings under extraordinary circumstances, regardless of a declaration of emergency. So as many of you know, starting in March of 2020, during when COVID was at its worst, and extending all the way through September of 2022, there was states of emergency in effect relating to the COVID healthcare crisis. And while those declarations of emergency were in effect, many public bodies were authorized to conduct their meetings completely remotely. And the reason they had the ability to have completely remote meetings was due to the statewide declaration of emergency that ended in September of 2022. So at that point, all public bodies had to revert to strict compliance with the New York State Open Meetings Law. The good news is the New York State Open Meetings Law always has had some provisions that allow for video conferencing. And in the spring of 2022, before the expiration of the declaration of emergency, the Open Meetings Law was amended to expand that use of extraordinary or video conferencing, but only under extraordinary circumstances. So the new provision that was passed in spring of 22 is not meant to change or curtail what has always been permitted or required of public bodies in relation to compliance with the Open Meetings Law. Public bodies may continue to operate now as they did before the onset of the pandemic in early 2020, when the in-person aspects of the Open Meetings Law were first suspended. In other words, if a public body was permitted to do it before the pandemic, this law does not change that. Law is intended to expand, in extraordinary circumstances only, the ability of public bodies to meet using remote access technology. So everyone should keep in mind that there are two ways to use video conferencing technology to conduct an open meeting. The first way is the way that has existed since pre-pandemic, and that is where a public body connects multiple physical locations that are open to in-person public attendance. So, for example, for many, many years, the Committee on Open Government, with our 11-member body, those people live in locations all over the state of New York. What we do is we set up meeting locations at 3 different Department of State offices. We set up a location in Buffalo, one in Albany, and one in New York City. All of those locations are noticed to the public and are open to attendance by the public. Any member of the public can show up to any one of those 3 locations to attend the meeting. Any of our members of the committee can also choose which one of those locations is most convenient for them. And then they attend from that location. And then what we do is we connect the 3 locations through the use of video conferencing. That's been permitted for a long time. All of those people that are present at all 3 of those locations all count towards a quorum, and you conduct the meeting as if everybody was in the same room. The second way to use video conferencing is the new way that is only permitted under extraordinary circumstances. And that's where a public body is going to allow one of its members to participate from a private location, a location that is not noticed to the public, that is not open to the public, through video conferencing, but again, only under extraordinary circumstances. If the public body is using the first type of video conferencing, where you're connecting multiple physical locations that are open to the public, the new provisions of the open meetings law do not apply. These new provisions are only going to apply to situations in which a member of the public body is participating from a private, unnoticed location. This new provision states that a public body may, in its discretion, use video conferencing to conduct its meetings pursuant to the requirements of the open meetings law, provided that a minimum number of members are present to fulfill the public body's quorum requirements in either the same physical location or locations where the public can attend. So in general, and there's going to be an exception that I'm going to point out to you in a little bit, but in general, in order for you to allow one or more of your members to participate from a private, closed location through the use of video conferencing, the public body must first have a quorum present at either a single location that is open to the public or multiple locations that are open to the public. In spring of 2023, the open meetings law was amended again to state that if an individual is attending through the use of extraordinary circumstances video conferencing, and that person has a disability as defined under New York State statute, and that disability renders the individual unable to participate in person at the meetings where the public can attend, in that very limited circumstance, that individual is considered present for purposes of fulfilling the quorum requirements. So in general, if you're attending under extraordinary circumstances video conferencing, you don't count towards a quorum. But if you're attending under extraordinary circumstances video conferencing and have a disability that prevents you from attending in person, then you can count towards the quorum. So I know it gets a little confusing. They keep, updating the statute and adding a little bit layer after layer after layer. So this is just my little summary here. If you're participating from a physical location that has been properly noticed and is open to in-person public attendance, you do count towards a quorum and may fully participate and vote. If you are video conferencing from a remote location that is not open to in-person public attendance, you do not count towards a quorum unless you meet the disability criteria. If a quorum is otherwise met, individuals that are participating using extraordinary circumstances video conferencing, once the quorum has been met through other means, that person may fully participate and vote in the meeting. In order to take advantage of these new extraordinary circumstances video conferencing, the legislature placed some requirements. You can't just automatically do it. The public body has to do some things first in order to allow its public bodies and the members of the public bodies to take advantage of this new provision. First, the governing board of a county, city, town, or village must adopt a local law authorizing the use of extraordinary circumstances video conferencing. The New York State legislature, including the Senate and Assembly, they were required to adopt a joint resolution authorizing the use of extraordinary circumstances video conferencing, and all other public bodies were required to adopt a resolution authorizing the use of the extraordinary circumstances video conferencing. All of these public bodies were required to have a public hearing prior to either adopting the local law or the resolution. A public body can pass a resolution just for itself, or it can pass a resolution that covers itself and all of its committees and subcommittees. We've also interpreted this to mean, for example, if you have a municipality, let's use for example, a city council. If a city council passes a local law that authorizes the use of extraordinary circumstances video conferencing, in our view, that same local law, they can indicate in the local law that it applies to all public bodies housed within the city. So for example, a city council might have, whether it's planning boards or Health and Human Services committees or finance committees, whatever the case may be, any city council, council's not the right word, any city committee or public body that is housed within that city can be covered by the local law if the city council chooses. Another option is for the city council to say, nope, this local law just applies to us, and all other public bodies that are housed within the city, housed by the city as an agency, have to make their own decisions and pass their own resolutions. Roman numeral 3 that you see up on the screen applies to New York City community boards. And the law states that each community board in a city with a population of 1 million or more, which is shorthand for New York City, shall make its own determination. The law states that the public body must establish written procedures governing member and public attendance consistent with this section, and such written procedures shall be conspicuously posted on the public website of the public body. Here, I think what I'm going to remind people is that prior to the passage of the statute of Chapter 56, the New York State Legislature held a public hearing. And they listened to what different interest groups had to say about the use of video conferencing. Ultimately, Chapter 56 is what they decided to pass. And I think by passing Chapter 56, they really have shown a clear preference for in-person meetings. They're not making it easy to allow members of a public body to attend remotely from a private location. And by doing so, as I said, I believe they're showing a very clear preference for in-person meetings. And the language here that you see sort of expresses that. The law states that members of a public body must be physically present at any such meeting unless the member is unable to be physically present due to extraordinary circumstances. Each public body must determine what they consider to be extraordinary circumstances, and that definition must be included both in the resolution or the local law and their written procedures. The law, the open meetings law, states that extraordinary circumstances includes disability, illness, caregiving responsibilities, or any other significant or unexpected factor or event which precludes the member's physical attendance at the meeting. When the Committee on Open Government passed our resolution and established our written procedures, we just plucked this definition from the open meetings law and popped it into our resolution and our procedures. So that's how we, as a Committee on Open Government, have defined extraordinary circumstances. The law states that in the case, except in the case of executive sessions, the public body shall ensure that members of the public body can be heard, seen, and identified while the meeting is being conducted, including but not limited to any motions, proposals, resolutions, and any other matter formally voted upon. I think this harkens back to the time during COVID when members of a public body were permitted to attend meetings via teleconference, or even if they were using a video conferencing platform such as Zoom or WebEx, there was nothing in either the executive orders or that temporary legislation that required that the members be seen. So while we heard a lot of complaints about members not having their cameras on during these meetings and only basically being present through their voice, there was nothing in either the executive orders or the legislation that required that they be seen. This changes that. So anytime you have a member that is not present at the primary meeting location and is attending via video conferencing, regardless of whether it's the type of video conferencing that is open to the public or the type of video conferencing, the extraordinary circumstances video conferencing from a private location, all members must be heard, seen, and identified, which means cameras on. And when the person logs on to the remote access platform through the video conferencing platform, they need to provide identification on their screen. So, whenever you log on often to a Zoom or a WebEx, they're going to ask for you to type in a name. All members of a public body must be typing in their full names so that when their face shows up on a screen, the public knows who they are. Another requirement of this new provision is that the minutes of the meeting in which extraordinary circumstances video conferencing is used must include a reference of any members who participated remotely, and they must be made available pursuant to the same requirements of the open meetings law that have always existed. So in addition to what's always been required in meeting minutes, if extraordinary circumstances video conferencing is used, the minutes have to include a notation as to which members participated remotely. If extraordinary circumstances video conferencing is used to conduct a meeting, the public notice for the meeting shall inform the public that video conferencing will be used, where the public can view and or participate in the meeting, where required documents and records will be posted, and identify the physical location for the meeting where the public can attend. So if you have a member that's attending via extraordinary circumstances video conferencing, the notice of the meeting must include directions or a link so that the public can also use that video conferencing option. The law requires that under these circumstances, the meeting must be recorded, the video conference must be recorded, and the recordings must be posted or linked on the public website of the public body within 5 business days following the meeting, and shall remain so available for a minimum of 5 years thereafter. And those recordings shall be transcribed upon request. If this type of video conferencing is used to conduct a meeting, the public body shall provide the opportunity for members of the public to view the meeting via video and to participate in proceedings via video conferencing in real time where public comment or participation is authorized, and ensure that video conferencing authorizes the same public participation or testimony as in-person participation or testimony. So this is also a bit of a change from the COVID provisions. During the executive orders and temporary legislation that were in place during the state of emergency, the law was silent with regard to public participation. Here, there's still no obligation under the open meetings law to provide a time set aside for public comment or public participation. But what this provision states is that if you do set aside a time for public comment or participation for the people that show up in person at your meetings, You must also allow for public comment or public participation by the people who attend via the video conferencing, via the remote access platform. You have to give the people that are attending remotely the same opportunity to speak as those who show up in person. This provision of the Chapter 56 amendment is intended to address situations where there's not many local public bodies that don't have websites anymore, but there are still some. There's still some very small municipalities that have not established their own website or have a very, basic or bare bones website that doesn't accommodate for the type of information that would need to be posted. So what Chapter 56 says that if a local public body wants to utilize this type of extraordinary circumstances video conferencing to conduct its meeting, it has to maintain an official website. And then, as we've already discussed, there's certain types of information that need to get posted on that official website. There's a provision that addresses situations such as if there's ever another statewide disaster emergency, or if there's a local state of emergency, either at the county, city, village, or town level. If the public body determines that the circumstances necessitating the emergency declaration would affect or impair the ability of the public body to hold an in-person meeting, it can instead suspend the in-person requirements of the open meetings and have a completely remote meeting, just like we did during COVID. But that's only under circumstances where the state of emergency would affect or impair the ability of the public body to hold an in-person meeting. The mere existence of a state of emergency is not enough. It has to be that there's the state of emergency and the situation that caused the state of emergency affects or impairs the ability of the public body to hold an in-person meeting. We're coming up on this deadline. No later than January 1st, 2024, the Committee on Open Government is required to issue a report to the governor and the legislature concerning the application and implementation of this amendment, and to make any further recommendations governing the use of video conferencing by public bodies to conduct public meetings. Annually, the Committee on Open Government is always required to prepare a report to the governor and the legislature, and that is due to the governor and the legislature on December 15th of every year. There's a very strong likelihood, although it's ultimately up to the committee, that this report relating to extraordinary circumstances video conferencing will simply be included in our general annual report that is due on December 15th of this year. So that's, if you're looking for the report that we make to the governor and the legislature, there's a strong likelihood that it will be included within our annual report that is due December 15th of this year. There's another requirement that states that if you are using this video conferencing technology, you must use technology that permits access by members of the public with disabilities consistent with the ADA. The term disability is defined in New York State Executive Law, Section 292. I'm going to provide the warning that I am in no way someone who is knowledgeable about the Americans with Disabilities Act beyond the bare basics. If you need advice regarding compliance with the Americans with Disabilities Act, I would encourage you to consult with your own agency attorney or municipal attorney, whatever the case may be, to get that guidance. I know one thing that we've added to our committee meetings is closed captioning. So I think that is one thing that has been added that we know that we've done to try to make it more compatible with the ADA. So that's sort of my, apologize, I have to take a break every once in a while to take a drink or else my voice will completely go before we end here. So that's where we kind of come to the end of our section of relating to the new video conferencing provision. From now on, we'll mostly be talking about existing provisions or a couple of amendments that have taken place in a couple of years relating to existing provisions. Notice. Notice of every meeting that is required to be held in compliance with the open meetings law must include the date, time, and location, and if appropriate, instructions for virtual attendance. That notice must be given prior to every meeting to the media. Does not mean that the public body has to purchase a legal notice, just that the notice must be provided to the media. The notice must be placed in a designated physical location, such as a bulletin board, outside signage, things of that nature. And if your agency or public body has an active website, the notice must be posted on the website. Timing of notice. Notice must be provided at least 72 hours prior to a meeting that has been scheduled at least 1 week in advance. For meetings that are held on short notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. The open meetings law is silent as to when a public body is permitted to have meetings on short notice, but for some time now, the courts have weighed in and have held that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. So public bodies should not be having meetings with less than 72 hours notice unless some sort of harm would be caused by waiting. If extraordinary circumstances video conferencing is used, the public notice has to inform the public that the video conferencing will be used and where the public can view or participate in the meeting remotely. Records scheduled to be discussed during an open meeting. On October 19th of 21, Governor Hochul signed into law Chapter 481 of the laws of 2021, which amends Section 103 of the Open Meetings Law to require that records to be discussed at an open meeting be made available to the extent practicable upon request and posted online at least 24 hours before the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. Just as a point of reference, the obligation to make records available to the public upon request prior to or at the meeting and to post the records on the agency or public body website prior to the meeting has been in effect since February of 2012. So this is not really a new requirement in general. The only part of this that's new is that the amendment places a 24-hour minimum time frame for making those records available. So where it used to be just had to be prior to or at the meeting or posted prior to the meeting, now those records have to be available at least 24 hours prior to the meeting, both upon request and online to the extent practicable. What type of records are we talking about? We're talking about all proposed resolutions, laws, rules, regulations, policies, or any amendments to any of those types of records. And any records or portions of records that are public under FOIL that are scheduled to be discussed during the open portion of the meeting. The law states that the agency may, but is not required to, spend additional money to implement this section, and it does not apply to records that are scheduled to be discussed during executive session. Minutes. Minutes of a meeting are required to include all motions, proposals, resolutions, or any matter formally voted upon and the votes thereon. If extraordinary circumstances video conferencing is used, it must include which, if any, members participated remotely. For executive sessions, minutes of an executive session must only be prepared if action is taken in executive session. If the public body votes in executive session, minutes must be prepared. But if a public body merely deliberates in executive session and then exits without voting or taking action, there is no obligation to prepare separate minutes of the executive session. In terms of timing, minutes must be available within 2 weeks of an open session and 1 week of an executive session. And it does not matter whether those minutes are unapproved or in draft form, they still must be made available. And going on 2 years ago, Governor Hochul signed into law Chapter 587 of the laws of 2021, which amends the open meetings law to require agencies that maintain a website and use a high-speed internet connection to post their meeting minutes on their website. For many years, we at the Committee on Open Government would hear from the public all the time, being frustrated that meeting minutes were not being posted on either the public body's website or the agency that posted the public body's website in any sort of timely manner. And our advice at that time was that there's really no obligation to post them online, but they should still be available in response to a Freedom of Information Law request. Well, that changed in November of 21. Now there is an obligation to post those meeting minutes on their website within 2 weeks of the date of the meeting or 1 week of an executive session. The law does state that for purposes of this posting obligation, an unabridged video or audio recording or unabridged transcript can take the place of posting meeting minutes. This does not mean that a public body is relieved of its obligation to prepare meeting minutes. Public body still has to prepare meeting minutes, and they still have to prepare meeting minutes within 2 weeks of a meeting. It's just that as an alternative to posting those meeting minutes on their website, they can choose to post unabridged video or audio recordings or unabridged written transcripts. Recording meetings. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and or transmitted by audio or video means, which means that if someone shows up to an open portion of a meeting and would like to sit there in their chair with their smartphone and hit record, they are free to do so. They're free to take pictures. If someone comes in with some type of video camera and they set up in a location that is not being obstructive, they're not interfering with the efficient and effective conducting of the meeting, they must be permitted to do that. The agency itself is not obligated to record its meeting unless one of its members is participating remotely under the new extraordinary circumstances video conferencing provision. An agency can establish reasonable rules to limit disruption and interference. And if a public body is looking to establish those types of rules, we do have model rules available on our website to use as a guidance. Executive session. So there's 2 mechanisms that allow a public body to meet behind closed doors. And the first mechanism is probably the most commonly known, and that's executive session. And it's defined in section 102.3 of the Open Meetings Law as a portion of an open meeting that is not open to the public. An executive session can never be held prior to the start of an open meeting, and it can never be held completely separate from an open meeting. An executive session can only occur after the start of an open meeting that has been properly noticed and open to the public. During that open meeting, a motion must be made to enter into executive session and voted upon during an open meeting. The motion to enter into executive session must be specific enough to reflect to fellow board members and to the public that you're going into executive session for a proper purpose. Up on the screen here, you'll see all the reasons a public body is permitted to go into executive session. As I noted earlier, this information is all available. First, it's available right in the statute. In addition to the statute, we have a publication called Your Right to Know, which provides a nice overview of both the Freedom of Information Law and the Open Meetings Law. And finally, I have PDF copies of these PowerPoint slides up on our website under the section regarding training materials and recordings. I'm going to go over a couple of the grounds for going into executive session that are sort of the most commonly used. Start with this one, which is always my favorite because I see it, I suppose, as a problem the most frequently, where public bodies like to use the term personnel. Public bodies, no matter how many trainings I do and how many times I say it, I don't think I'm going to imagine that I'm going to retire well before I see the disappearance of the phrase personnel in either agendas or meeting minutes reflecting the reason for entering into executive session. But I can advise that it is not acceptable under the statute. It is not sufficient to comply with law. There are plenty of judicial decisions that reflect this. This is not just the Committee on Open Government's opinion. It is the opinion of the courts that a motion that states that a public body is entering into executive session to discuss personnel matters is not sufficient to comply with law. If you'll read through the statute, you will notice that the word personnel does not appear anywhere in the open meetings law. What public bodies are usually talking about when they state that they are going in to discuss personnel matters is the provision of the open meetings law that allows a public body to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. So I mentioned earlier that a motion to go into executive session should be specific enough and sufficient enough to reflect to your fellow board members and to the public that you're going in for a proper purpose. I am not suggesting that you merely parrot the language of the statute. In fact, the courts don't like that either. What you want to do as a public body is to look at the language that authorizes the executive session and see how what you want to discuss fits within that definition, or not within the definition, but an example of what you're permitted to discuss. So, for example, if you as a board are reviewing the employment history of several individuals who have applied to fill a particular position within your agency, you may make a motion to enter into executive session. Let's use, like, for example, a library board of trustees. A library board of trustees may move to enter into executive session to discuss the resumes and as such the employment histories of particular persons who have applied to fill the position of executive session, or excuse me, executive director, I'm sorry. That would be a good motion to enter into executive session. You don't need to identify the applicants. You just want to be specific enough that that the public knows that you're going in for a proper purpose, but not so specific that you're defeating the purpose of the executive session. Another example might be if there is a disciplinary matter involving one of your employees. So the public body may move to go into an executive session to discuss potential disciplinary actions or says the suspension, dismissal, or removal of a particular person. That would be a good motion to enter into executive session. It is specific, but does not identify the individual who is going to be discussed. I'm going to go back, excuse me, I just want to go back a slide or two because that's, so here we're back to the full and complete list of reasons a public body is permitted to go into executive session. I'm going to just pick a couple of them. D, the letter D, says a public body is permitted to have discussions regarding proposed, pending, or current litigation. So this means you're discussing litigation strategy. A public body is discussing litigation strategy relating to either litigation that is currently pending in the court system or litigation that has been very specifically proposed. And here, I use notice of claim as a good indicator as to whether there is proposed litigation. If you, as a municipality or a government agency, has received a notice of claim, I think that can be characterized as proposed litigation. What a public body wants to be careful of is not to confuse proposed litigation with potential litigation. The word potential is not used. Every time a public body takes action on any item, there is the potential for litigation. A public body cannot discuss any matter that they fear may lead to litigation in executive session. They have to be discussing the actual litigation, not the matter that may potentially lead to litigation. Letter E is collective bargaining negotiations under the Taylor Law. We already talked about F. H is the proposed acquisition, sale, or lease of real property or securities, sale or exchange of securities. It's proposed sale or lease of real property, proposed acquisition of securities, or sale or exchange of securities, but only when publicity would substantially affect the value thereof. Here we'll use an example. If a municipality is considering purchasing a piece of property and they want to go into executive session to discuss how much they might be willing to offer to purchase the property, that's an appropriate conversation to be held in executive session, because if they let the entire public know how much they're willing to offer, it's going to put the municipality in a weakened bargaining position. Like, for example, maybe they're going to say, okay, well, we don't want to go higher than $100,000. Then in that case, then the person who's, maybe they'd like to start out lower. They want to only, the starting offer is 70,000. They know they don't want to go above 100, but they're going to start out at 70. Well, if the public knows that they're willing to go up to $100,000, then the owner of the property is going to say, well, I'm just going to wait until they offer me 100. So again, it's just about whether knowledge of the conversation being held by the public would affect the value of the property. So as I mentioned a minute ago, is that there are two avenues for meeting behind closed doors. The second mechanism is called exemptions, and that's in section 108 of the Open Meetings Law. If an exemption applies, the Open Meetings Law does not. It's as if the Open Meetings Law does not exist. You throw it right out the window. There are three exemptions within the Open Meetings Law. One is judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. One example that I see fairly frequently is boards of assessment reviews. Boards of assessment reviews often engage in quasi-judicial proceedings. And from our perspective, a quasi-judicial proceeding is a type of hearing held by a public body that is the last step in the decision-making process. So with a Board of Assessment review, if they make the final decision on the behalf of the municipality, and the only remedy to the person who has brought the petition before the Board of Assessment review is to initiate litigation against the municipality, then that is likely going to be considered a quasi-judicial proceeding that would be exempt from the obligations, from the requirements of the Open Meetings Law. The second exemption is deliberations of political committees, conferences, and caucuses. So if you have a public body that contains elected officials, people that were elected to fill those positions, and let's say you've got 3 Republicans and 2 Democrats that serve on that municipal board, I try to switch this up every once in a while. I'm not picking on Republicans or Democrats. I just try to pick one or the other. The Republicans, even though they represent a quorum of the public body, because they're all adherents to the same political party, they're permitted to meet wherever they want, whenever they want, and talk about whatever they want without having to meet in compliance with the open meetings law. They can't vote, they can't make decisions, but they are permitted to talk about whatever they want, which can be very, I'm sure, frustrating for the individual or individuals who are in I suppose, the minor party, the party that has less elected officials serving on the board. The third exemption is any matter made confidential by federal or state law. For example, discussions relating to students that are held by a school board, and those discussions are made confidential by the Family Educational Rights and Privacy Act. Another very common example of an exemption under the matter made confidential by federal or state law are where you have your public body meeting with the public body's attorneys. So you have a town board, and the town board is meeting with their town attorney for the sole purpose of requesting and receiving legal advice. That conversation is made confidential by the attorney-client privilege and can be held completely outside the scope of the open meetings law. It's not an executive session, it's an exemption. A conversation that is covered by the attorney-client privilege is exempt entirely from the open meetings law. But it is, just as a reminder, the mere presence of an attorney at a conversation is not enough to trigger the attorney-client privilege. The attorney has to be playing an active role in providing the type of advice that only a licensed attorney is authorized to provide. They have to be providing legal advice. So it has to be for that sole purpose. Once the attorney's active role in the conversation ends, and the public body wants to then go on and deliberate and discuss what they're going to do based on that legal advice, the exemption ends. The exemption ends once the attorney's active role is complete, and then any further conversations by the board must be held at a meeting held in compliance with the open meetings law. Non-compliance and enforcement. The Committee on Open Government does not have enforcement authority. We do not have investigatory authority. We very frequently get emails or phone calls saying, I'd like to file a complaint against so-and-so, or I'd like you to please, contact this agency or this public body and tell them that they have to do this, that, or the other thing. We do not have that authority. The Committee on Open Government was created to provide advice and legal opinions regarding the open government statutes, but we do not have enforcement authority. This sole enforcement mechanism created it for both the open meetings law and the Freedom of Information law is through the initiation of a civil practice law and rules Article 78 proceeding against the public body or the agency. For purposes of the open meetings law, when a petitioner substantially prevails in one of these proceedings, the court has the authority to award costs and attorney's fees to the prevailing party. They have the ability to invalidate actions taken at meetings held in substantial violation of the open meetings law. The law specifically states that a mere technical violation is not going to be enough to allow a court to invalidate an action. A court is going to have to find that there were substantial violations of the open meetings law, either at the meeting where the decision was made or at meetings that led up to, where discussions were held that led up to the ultimate decision. The court is going to have to find that there are substantial violations of the open meetings law to have the authority to invalidate the action. And a third penalty that the court can authorize is that the public body has to receive training from us at the Committee on Open Government. We hope that people don't feel that we are a penalizing entity. We are here to help anytime anyone from the public, from the media, but government employees, whether you work for a local government or whether you work for a state agency or any person, any member of the public is welcome to contact our office at any time with questions relating to the open government statutes. Just as a reminder, we are not sometimes people contact us with questions outside the scope of our advisory jurisdiction. They want questions about compliance with municipal law generally, for example. We have a limited function. We're a tiny office and we have a limited function, and that relates to providing legal advice regarding the Freedom of Information Law and the Open Meetings Law, and for state agencies, the Personal Privacy Protection Law. But if you do have questions about one of those statutes, please do not hesitate to reach out and contact us. You can call us at the phone number that's on the slide or on our website, and our email address is coog@dos.ny.gov. So we've got a little time left on the WebEx for people that are interested. I'm going to stop sharing. I'm going to turn on my camera here, even though the lighting's not great here. I'm sitting in front of an open window, which you're not supposed to do. I want to make the chat function available. Let's see, one moment, sorry. Where's my chat function? Chat. Sorry, I'm having a hard time. It was there a second ago. Menu bar. Oh, this is silly. I've never had this problem before. Usually chat function comes right up. I think they changed my WebEx a little bit. Sorry about this. They've just changed WebEx apparently just enough to make things confusing for me. It was up earlier because I know I entered things in. Well, here's what I'm going to do. I don't think there are I don't think there's a lot of us. There's only 22 of us that are available on the program right now. Let's see if I can try to unmute. I don't even see the raise hand function. I hate it when they change the WebEx on me and then I don't, oh yay, I found chat there. That's the easiest way to do it. Sorry. Like, oh, I hate it when they move things around on me. Okay, I found chat. Already some people have entered some questions into the chat feature. That's wonderful. And I'll start by going through those. I'll take this opportunity to remind everybody that this program is being recorded and will be posted on the Committee on Open Government's website, hopefully no later than the middle of next week. The PowerPoints are available on our website as well under the section on view training materials and recording. And I'm going to start going through questions, but if people continue to have questions, I will keep going until I've gotten through them. All right, so the first one I see is during video conferencing, some members of a local public body have been known to turn their cameras off, supposedly for a private exchange with family members or phone call with unidentified party or similar. Some members have their cameras on, but the camera is aimed elsewhere in the room and not on the member themselves. As we mentioned during the discussion, the law requires that all members must be seen, heard, and identified during any deliberations and discussions and votes. If for some reason there's a break in the action, I suppose they can turn their cameras off temporarily. But in general, during the entire open session of the meeting, they're supposed to have cameras on and they're supposed to be seen, heard, and identified. The question next is, what is the threshold definition as to what constitutes impairment for purposes of holding a public in-person meeting? I'm not sure if this question relates to the declarations of emergency. I think a good example would be going back if for some unfortunate reason we had a significant uptick in COVID or maybe a flu pandemic, some sort of public health crisis where there's been either a statewide declaration of emergency or a local declaration of emergency, where having in-person meetings would cause a public health threat, I think that's a good example of a situation that would impair the public body's ability to have an in-person meeting. Some people have asked us about like whether when there's a snowstorm. My feeling generally is with something that temporary, if there's my first inclination would be to cancel the meeting. If you have something like there's a local state of emergency relating to a weather issue, where people have the inability to travel, my first inclination would be to cancel the meeting. However, if there's a really good reason why, if the state of emergency isn't in effect, and there's a really good reason why this public body needs to have a meeting while the state of emergency is in effect, and that state of emergency, and there's whether it's a snowstorm or hurricane weather, whatever the case may be, that's a situation where you want to just make sure you're being, careful and thoughtful about providing public access. So that might be a situation that would impair the ability to hold an in-person meeting. But certainly if it's a temporary situation like a snowstorm and you can reschedule for the meeting at a later date, that would be my recommendation. Next question states that you mentioned that the public can request transcripts of a public meeting, but I don't remember if you mentioned where that is in the open meetings law. It's one of the provisions. So the new provisions that were passed in spring of 2022 are all contained in section 103A of the open meetings law. So the obligation to prepare a transcript is in section 103-A, but again, that's only if the public body is taking advantage of the extraordinary circumstances video conferencing. And in that case, they're required to record the meeting, post the recording on their website within 5 business days, and then transcribe upon request. Next question is, what happens when a body consistently uses extent practicable as their justification for not posting? It's not really a question I can answer in this setting. It's very specifically, it's very factually specific. So that's something, the person who asked the question, if they have a specific situation, we can discuss. Question is, may a board vote in executive session to pay a claim? What is an appropriation which cannot be voted on in executive session? Appropriation is a budget term. If it's money that has not been set aside for a specific purpose, and the board now has to take that money that has previously not been set aside for that purpose, I think to pay a claim, that does not sound like money that's probably been previously appropriated. So that is not something that can be voted upon in executive session. I will note with voting in executive session, I'm sure there are situations where the vote in executive session seems like a good idea, but also you need to keep in mind that you still need to prepare the minutes of the executive session. So I'm not sure what the purpose of voting in executive session would be when you still need to prepare the minutes that have to be available within a week that reflect that vote. So for something along the lines of voting to pay a claim, my thought is, why don't you just, have the conversation in executive session and then come out and vote in open session. Again, you can vote in executive session, but you still, if it's not to pay a claim, to not pay an appropriation, as this commenter points out, there is an exception that states that you cannot vote in executive session to appropriate public monies. That's the language of the statute. So I think anytime you are voting to spend money that had not previously been set aside for this purpose, then it's a vote to appropriate public monies, and that vote must occur in public session. If there are journalism students notified of a public meeting, does that meet the requirement to notify the press? No, it does not. You have to notify the media. Media is professional media. That's how I believe it's defined in general construction law. A journalism student is not going to be sufficient to comply with the statute. Is the body required to provide public access to the virtual meeting when it is available to the attorney of the body who attends virtually? I think I understand this question. If it's not a member of the public body that wants to attend via video conference, but instead a staff member or the municipal attorney, in that case, the provisions of the open meetings law don't apply. The video conferencing provisions of the open meetings law only apply to individuals who serve on the public body. If it's, for example, maybe a staff member who wants to attend and present information to the board, or if it's the town attorney, village attorney, city council, whatever the case may be, who wants to attend via video conferencing, none of those requirements of the open meetings law are going to apply in that situation. Follow up here, the following is on the agenda: executive session for personnel, but the minutes reflect executive session motion by supervisor, seconded by councilwoman to enter into executive session for potential litigation. No, none of that sounds right. Well, first of all, I mean, I'm not worried too much about agendas. There's nothing in the open meetings law that requires that agendas be prepared or that they be followed. So the language that's included in the agenda is somewhat irrelevant. What matters is the language that's used during the meeting. And of course, whatever language is used during the meeting should be accurately reflected in the minutes. So again, it doesn't really matter what the agenda says. It matters what they said during the meeting. And then the minutes should reflect what was said during the meeting. And as we discussed during the presentation, potential litigation is not a reason for entering into executive session. In general, when you're entering to go into executive session to discuss litigation, the courts have held in most circumstances that you should be identifying the litigation that you plan to discuss. So for example, if I, for some reason, wanted to sue the Department of State and whatever, I don't know, that doesn't really make sense. Like say I wanted to sue the city of Albany. The city council for the city of Albany would say we move to go into executive session to discuss the case of O'Neill versus the city of Albany. That's what should be occurring. But again, potential litigation is not a permissible statutory reason for entering into executive session. So we've come to the end of the questions that were entered into the chat feature. Thank you everyone for joining me today. If anyone thinks of follow-up questions that they have later today, you're always welcome to email us in the coup@dos.ny.gov account. If the question is for me specifically, you're always welcome to say attention Kristen O'Neill, that's fine. Please remember, recordings will get posted online, materials are available online. I always invariably get somebody who emails me and asks me for either a recording or a material, so I'm hoping to avoid that. But I appreciate everyone joining me today. I am having a program on FOIL today, but I can fully understand if one program relating to open government is enough for any of you. So have a wonderful day and a good week. Thank you very much. Bye-bye.